Live. All right, hopefully that's working. We just hit the Let's Go Live button. Good morning. Hopefully you guys are doing well. Happy Valentine's Day. If hopefully you're doing something special. And I'm excited today. It's going to be good. We're going to go through three major points that I want to cover today. The first one is going to be the court filing that we're reading today is going to be the TRO, the temporary restraining order that Eric had, which is probably why he didn't get onto that original Zoom call that was supposed to happen. I think it was on the 7th. So we'll talk a little bit about that. In this filing, they also go through kind of a response to Eric and what he said in his original lawsuit. And then I got a video from Greg Kapp. I don't know if you guys have seen that yet. It was out on social media. So apparently Greg Kapp has moved over. And so I want to talk a little bit about that. We might even have some time for Q&A. So if you have any questions, throw it in the chat. And if I can answer anything or direct you to the right area, I'd love to be able to help you. And I just want to say thank you. You guys have been awesome. I think we're about 10,000 views on those last 3 videos. And everybody's been super cool. Probably 95% of you guys have been great in like saying thank you and that you appreciate the information. It's helped you make some good decisions. So I'm glad that it was useful, at least that some of these things have helped you in your decision of either staying with WFG, moving to WFG, or moving to GFI, or just figuring out what's going on and how to handle that best for your life. So anyway, hope you guys have a great Valentine's Day. My wife and I, we're going to get some couples massage, except for bringing mom. So I don't know, that'll be interesting. But let's get into this thing and we'll start going through this lawsuit. So let me pull this up. How many people have moved over now? I think we said that, I think on Monday, about 4,000 agents, they're saying at least, have moved over. That was a couple days ago, so it could be 5,000 or 6,000 by now. Defendants do not deny the conduct of which they are accused, which was interesting. They have not really responded back to what WFG is saying that they're doing. And anytime that they do, they basically just say, well, it's okay. They just inappropriately attempt to hide behind the inapplicable state statutes to excuse and continue their misappropriation of WFG's confidential information to lure on false pretenses and false promises WFG agents to their brand new competitor company. So yeah, they're not fighting back at all, which is interesting. They're basically saying, yeah, we did all of the stuff that WFG is saying that we did, but we did it because we think that the law is not appropriate, that we think that it's illegal to have a non-solicitation, which is kind of interesting. And they're doing it for the purposes of stealing WFG's business. Defendants must be enjoined from their continuing unlawful efforts to raid WFG, which are causing irreparable harm to WFG with each passing day. That harm will immensely escalate as defendants increase their public dissemination of WFG's confidential information in Olson's highly publicized February 7th tell-all. So remember, this was written on the 4th, on 2/4. So this was right before, this was their attempt to kind of stop that from happening. This is why I'm assuming he didn't show up. So opposing WFG's request for the TR temporary restraining order, defendants made a single argument ad nauseum on which their entire opposition rests, that the defendants' blatant misdeeds are excused by California's prohibition of the restrictive covenants, but Business Professional Code 16600, and I appreciate whoever sent that to me. For whatever reason it didn't open and I haven't had a chance to get in there and read it, but basically they're saying that it does not invade the lawful contracts in use, nor does it excuse defendants' actual misuse of WFG's confidential information to raid in their unlawful actions, taking with intent to steal WFG's business in their desperate attempt to paint their contractual obligations as unlawful non-compete provisions, which they are not. This is obviously the plaintiff saying that, so the judge is going to have to make a determination on that. Defendants mischaracterize and misconstrue WFG's claims. WFG's complaint alleges, and its evidence shows, that defendants breached their contract's confidentiality provision, which is narrowly tailored and does not fall under sections 16600, and defendants continue to steal and rely upon WFG's confidential information in real time. Defendants' corporate raiding scheme is only just beginning. WFG will face further irreparable harm without injunctive relief to maintain status quo, prohibiting defendants from continuing to violate their bargained for contracts. The court must enjoin the defendants, must stop the defendants from this illegal contact by granting WFG's motion for a temporary restraining order. So basically they're trying to stop the raid of all of the WFG's clients and agents in this process. So their argument for this, this original part, somebody was asking me to, like, when is it actually going to happen? They keep moving the courts based on jurisdiction and where they want it to happen. So a snap removal, this was filed by Eric. So Eric wants to move it to federal court. I don't know what his play is there, unless it's just to slow it down and play it out as long as humanly possible. But WFG is basically saying that we don't want to go to federal court for whatever reason, and that they want it to stay in the jurisdiction that they're currently in, which I believe is in California. So they kind of talk a little bit about that, which you can read on your own if you want to. Defendants have already properly been served for removal. So they're basically debating why this snap removal, moving it to the federal government, is not real. They're calling it gamesmanship. They're basically saying that it might lead to unfair results, which they're obviously quoting these, and we're going to skip over a bunch of this case law. But here the defendants have consented to and received service prior to removing this action. So apparently they were trying to get it into California, and then after that, now they're trying to move it to the federal court. So they're playing a little bit of a shell game, and I think maybe at the end we'll talk a little bit about this, but there maybe something else is going on behind the scenes. And so their effort to deny the fact constitute very gamesmanship. So even the lawyer here is saying they're just playing games with us. They obviously don't know what's going on yet, but they're like, why are you moving stuff around so much? And so they don't want it removed, and that they're saying that the court should not allow it to go into federal court. So on January 22nd, attorneys Olson via email advised that he would be representing Olson. Serve this email. They're kind of talking about what's in that email. And then they consented to an email service. So basically what they're saying is they're opening up a line of communication that's not always necessarily used. A lot of times when you file things, you have to send it in the mail. You have to have a receipt that it got delivered, those kinds of things. But they open up communication via email, so it alludes to the fact that they're able to respond and send legal notifications via email. Okay, so regarding any legal precedents between WFG and Olson or her company, contemporary with their filings. So they're going into this emailing back and forth instead of having to send the legal documents back and forth. The previous lawyer, Spalding, again, hereby confirmed his consent to email service on behalf of Olson and Sandra. WFG provided notice to Spalding of WFG's intent to seek a temporary restraining order against the defendants. The following day was required as required by California rules and courts. WFG filed its complaint on January 25th. WFG emailed service copies of these documents to their lawyer and to Ms. Olson's counsel the same night. On the 26th, Olson, through new counsel, informed WFG that defendants were removing the action to federal court. So I don't know why, but Olson apparently switched lawyers and then is now trying to move it to federal court after they already started the process of doing it in California. So for whatever reason, they're kind of fighting this particular area. Maybe the new lawyer recommended taking it to federal court. Defendants' improper utilization of snap removal runs afoul. Basically, they're saying the way that they're doing this is not proper. To extend, the defendants now argue that they had not been served. So Eric, or the defendants here, Eric and Sandra, are basically saying that they never received the paperwork, even though they opened up communication via email. Their argument entirely is unavailing. Rule 4 does not require that a party executes the waiver of service to accept service by email. It's inapplicable here because they started the process via email, so that opened up that line of communication. So it shouldn't matter if they're getting a paper copy or not, which basically is what it seems like they're trying to avoid. So defendants took advantage of California's 10 a.m. ex parte notice requirement. Basically, you have to file in a certain amount of time, and they filed like right before that. The purpose of such requirement is to ensure that defendants are aware that there are emergency proceedings occurring against them, not to allow them to lie in wait after receiving such notice and rush to federal court to moot, circumvent, or delay the court emergency proceedings. Because WFG was asking to go fast. They filed to be able to get information, because basically WFG has to build a case against Eric, but they lack the information that they need to build the case. So what they would do is they would request that information from Eric. Things like, we want to see your text messages, we want to see your phone calls, we want to see messages that you've sent out, what are things on social media. They want to gather all this information to see how big of a scheme and who is involved. So they put a rush on that, and maybe Eric moving it to federal court is to bypass that expeditiousness of WFG to want to gather information, and moving it to federal court, and then they have to start this process all over again. So this is kind of what they're arguing about right now. The third, defendant's subterfuge in avoiding service continues. WFG made 4 attempts to serve the defendants at their home over the course of 4 days and at different times, starting on January 26th. Defendants are clearly avoiding any kind of service in their matter, continuing their gamesmanship. Meaning they're supposed to get, if they're saying that we can't get it via email, well, then you're supposed to deliver it in person, somehow designate that they actually received the documentation of the lawsuit. And it sounds like, or what they're alleging, is that Olson and Sandra are basically just avoiding any kinds of service. I don't know how they're doing this. Maybe they're staying at a different place, maybe whatever it is that they're doing, but they're trying to avoid, or WFG is not able to serve them. So it's kind of continuing things on, progressing longer than they probably should, because they can't get the proper firework filed because Eric and Sandra are not receiving them. So this court therefore lacks jurisdiction over this case, because Eric was in fact joined and served as a defendant in this action before it was removed. Even if Olson had not been served, defendant's actions were the exact same conduct that precedes absurd results in this context and should not be permitted. Let's see if any of this is important. Defendant's torture, no. Okay, whether and when snap removals under section 1441 are appropriate in continuous area of law that has resulted in the circuit split. So proprietary snap removals unsettled in the night. So again, they're still debating this whole snap removal. They're going to go into a bunch of case law on why they shouldn't be allowed to do that. Other people have done specific things. Oh, U.S. International Bank and Pacific Life, interesting. Okay, I just caught that. Basically, they're rejecting that. In this district, snap removal has never arisen in circumstances on all 4 of these. So these are 4 different cases that they cited something similar happening. And in all 4 of those cases, they denied it. So particularly in the unique posture of a temporary restraining order. The temporary restraining order is important here for WFG because that's kind of, if Eric was to keep doing the things that he was doing, now they have more leverage in the lawsuit to be able to go after him if he's violating this restraining order. And then they're basically talking, so in Roundup, this particular judge, with the view of interpreting the state to permit removal before service of process, would create an absurd bias. So they're helping this judge make the decision that they want him to make by citing other case laws that have already happened and judges who sided in something that's favorable to what WFG would want. Okay. They're going to continue through this. Defendants attempted exactly that. Acknowledges the party's conduct may make SNAP removal inappropriate. Apparently, if there's certain conduct that's involved, then SNAP won't work, which is what they're citing in those particular cases. Defendants' case on this point are unavailing for at least 3 reasons. First, they are not binding in this court. 2, none of these cases involve a temporary restraining order, and the pre-filing notice requirement imposed by California law, which alerted defendants that service would be imminent. So basically it tells them that, hey, you're going to be getting served, and maybe that's how they're avoiding being served. Finally, none of the defendants' cases display the level of gamesmanship here. So in what WFG is saying is none of the other previous court filings, they haven't played games like what's being played here, so these should default into not allowing them to move onto federal court. For example, in Humana, the plaintiff argued that defendant evaded service by failing to update its address for service on the California Secretary of State website in violation of the law, but the court found no evidence that the defendant purposefully blocked the defendant's attempt to service. So if the judge did go in and look at it and saw a different perspective, they're citing this particular reason of why the judge still moved forward with it, even though there was because there was no evidence that he purposefully didn't change his address, which is what they're alluding is different to what Eric and Sandra are doing. So there, the plaintiff had never attempted to contact the defendant's counsel and easily served the defendants only a few days later by doing so. The circumstances here are vastly different. Doe defendants, so these are still the unnamed people. This is part of the reason why they want the documents from Olson, the text messages, the phone calls, the emails, because they don't know who these particular people are as of right now. They're still in discovery on that. They named some of them in the last one, but those particular messages, and I think this is why he was using the one that self-deletes, so that they can't track this stuff if they were to get a hold of his phone. So the court asked the parties to consider the difference in language between these different ones, which refers to the parties in interest properly joined as served as defendants, which refers to all defendants who have been properly joined and served. In this particular docket number, the presence of Doe defendants here implies that difference in language. Refers to party of interest of defendants who have been properly joined and served. So again, they're still kind of talking about that whole aspect of moving to SNAP. So defendants here in parties and interest who could not have been joined. So a lot of these people haven't been able to be served yet because they don't know who they are. So you obviously can't go after somebody if you don't know who they are. So that's why they need to do discovery. And that's why they're trying to do expedited discovery, because the longer that this goes on, the more likely it is that all that information is deleted and that the raid continues to happen. So WFG's ongoing investigation need for discovery, as described in WFG's non-concurrently filed motion for expedited discovery. But because Eric's avoiding being served, he doesn't have to go through discovery yet because he hasn't been told that they're going to do discovery. So you can see kind of the shell game that's happening here in the moving parts. The defendant scheme has a nationwide reach, creating a real possibility that the Doe defendant, the unnamed people, could destroy diversity jurisdiction, meaning depending on where these people live could change this lawsuit as well. specifically requires that all defendants consent to removal, and since they don't know who all the defendants are, then they obviously can't consent to removal because they don't even know who all the defendants are yet. So, which the defendants here have not. So obviously, if we don't know who they are and we haven't served them, they also can't consent to remove because we can't even tell them who they are. So if the Doe defendant's potential citizenship is not taken into account for the diversity purposes, they have not had the opportunity to consent to this removal. So even if they say, well, yeah, they might live in other places, the diversity purposes, that doesn't really matter, we're going to take this anyway. Well, they also haven't been able to consent to removal, so that should stop them from moving to the next court. WFG agreements are discovered by Georgia law. Defendants acknowledge that each of their WFG agreements contain Georgia choice of law provisions. 10 arguments that California Labor Section 925 voids their choice of law provision is wrong. They're going to say why they think that's wrong between employees, employers offered as a condition of employment. Here, defendants are going to cite more code according to that. Even if the defendants were employees, which they are not, both of their WFG agreements contain an opt-out provision for the applicable Georgia law. Because you got to remember, each state has its own laws. So for WFG to say compliant with that is not an easy thing to do. And so basically now they're citing particular Georgia state law, but they apparently have an opt-out provision of the application of Georgia law, and neither of them had submitted that, nor do they contend that they tendered to opt out of WFG. So they haven't done any of the requirements to meet that particular code. There is a reasonable bias for the parties section of the Georgia law. WFG and defendants both registered to do business and actually do business in Georgia. At the time the parties entered into their agreements, WFG had its headquarters in Georgia, which is where WFG's core executive administrative functions occurred. WFG's current employees who work in operations, compliance, supervision, marketing, provider relations, and accounting are in Georgia, so that's why those particular laws apply. WFG has established a likelihood to succeed on merits of its claim. So WFG feels like they're in a winning position on this because of the claims that they have. And so that should also help them stay, at least in their case, in the area that they're in. WFG is likely to succeed on the merits of its claims, surpassing the threshold, showing a fair chance of success to merit required to the temporary restraining order. WFG likely to succeed on its breach of contract claim. Even if Georgia law does not apply here, WFG is likely to prevail its breach of contract under California law, despite defendants' repeated instance of WFG agreements contain de facto non-compete provisions. They do not. According to WFG, they don't break that law. California law permits, as has always permitted, parties to enter into agreements to refrain from disclosing confidential information, not to disparage one another, and not to rate each other's work for it. Which is interesting because I just got a copy of GFI's agent agreement, and I haven't had a chance to go through all of it, but it's very interesting because they have almost a lot of the things that they're claiming are against the law in California is exactly what's in their agent agreement, that you can't take clients, you can't take agents, anything that you have that's GFI related is provision is owned by the company. They go even as far, you guys got to see this. We'll talk about it maybe Friday morning. We'll go through that one. But you've got to see what's in that. They even say that prospects are ownership of GFI, meaning I don't know if they have some kind of system that they're going to be putting it into. I know some of our the leadership in WFG does that. But if you put a name into that and they never become a client and then you leave, and you contact that person 2 years later and have them become a client within 2 years of you terminating, they're saying that they could sue you for that, which is way more strict than what WFG has. So that's going to be really interesting. I don't know how, WFG, I wonder if they should bring that up. And obviously, I'm not a lawyer, but it would be interesting that they're contending it on one side while they're going to enforce it in their company on the other, and even more strict. So that's kind of fascinating. WFG's confidential provision is valid and enforceable. So defendants argue Section 1.8 of the WFG agreement is overbroad and constitute an illegal non-compete. Neither argument is persuasive. The opposition cherry picks and cites the confidentiality provision out of context, intentionally leaving out limited principles. For example, defendants fail to include the final sentence in Section 1.8, which reads, confidential information does not include information which becomes generally available to the public. Moreover, Section 1.8 further limits the defendants do not highlight the definition of confidential information to mean information that is not generally known by a competitor or potential competitors of WFG, and includes but is not limited to hierarchy list, personal identifiable information, because in the WFG system, they have people's phone numbers, addresses, as far as how much money they make. All of that stuff is supposed to be confidential information. Is kind of part of having access to it, is that you're not supposed to violate that. And that's all in there that they're saying that they're using. So deemed to be confidential information by applicable federal, state, or Commonwealth laws, lists of WFG agents, including their identities, contracts, and information. Confidentiality agreements such as WFG have consistently been upheld as viable and enforceable. So here's some other case law that kind of support this particular action. These limitations squarely distinguish WFG's confidentiality provision from the contract at issue here. Contained in a broad context. Hierarchy means certain data. First, the confidentiality agreement in Brown contained broad, all-encompassing language such as information in whatever form used or usable in organized, developed or acquired for use or about or relating to the business. So they're saying in this particular lawsuit, they were too broad in the language that they used, but they're claiming that they're not too broad. All right, the WFG agreement confidentiality provision contains no such ambiguous definitions. Instead, it narrowly defines confidential information obtained by WFG, proprietary information by WFG. Second, the party challenging the confidentiality provision in Brown argued that the industry of statistical arbitrage, one cannot be profitable if they are limited to using only public information available. Not so here. There is no credible argument that insurance agents like the defendants can only be profitable by using confidential information, non-public information, even in their recruiting of other insurance agents. So basically they're saying there's no real ground for that because Eric and Sandra can go continue their career selling insurance without the confidential information that's provided by WFG. There's nothing that's stopping them from doing their career in whatever capacity they want outside of that confidential information. Finally, in Brown, the breach of the confident was not defended at all. WFG's confidentiality provision is defensible and is not an inevitable disclosure covenant as the defendant insists. The confidential information solely by WFG by defendants have routinely been determined by courts to constitute a breach of contract. Okay, so these are other law provisions that have basically happened. So defendants and co-conspirators, this is the one that we talked a lot about before, used their access to WFG business contracts, provided specifically confidential terms, pricing of those commercial agreements. So I don't know all of the information that he potentially has, but maybe he has information about contracts with particular carriers and how much they're paying and all of that kind of stuff, as far as contact information that he's received from them, all those kinds of relationships that he's already built with the actual product providers to maybe allow him to come over and do some of this as well. Without WFG's authorization, defendant reveals WFG's compensation structure in public Zoom meeting by comparing WFG's payment structure to those by the competitor. Defendants utilized WFG's unique proprietary and confidential hierarchy structure, and the list threatened and hierarchy list identified WFG insurance agents to target for recruitment to GFI. So they're using the system to go after the top performers and recruit them over to GFI and threaten agents with the loss of their hierarchies if they do not move. So we talked about this in the last one, but if you missed it, basically what they're doing is if the SMD, let's say the general manager, if you're not familiar with our terms, if he doesn't want to go, they're basically going under and talking to all of those guys and then pulling those guys over and saying, well, if you don't come with us, you're going to lose all of your income. So they're not necessarily keeping the structural integrity even in moving over to GFI. And so that kind of puts the SMD in a unique situation. Let's say if they have 20, 30, 40 agents working under them, those agents want to move over and stay with Eric. Well, now that SMD, he's basically being robbed from all of the work that he's done in building these people. And if he doesn't move over, not just move over, but he's breaking contract to move over, which opens him to lawsuit, then they're basically being threatened with that. All right, more case law. Defendants obtained the compensation structure and data from WFG's insurance agents, which are confidential between WFG and those insurance agents, to induce insurance agents by falsely comparing what they could make with GFI if they left WFG, thus obtaining a recruiting advantage against WFG. So they're taking this particular information that they have, and they're then building their structure to recruit insurance agents opens. And this happens, it seems like, in every single one that's happened. PHP did it. All these other guys do something similar where they make it a little bit more attractive for somebody to come over, right? Because they're not just going to come over necessarily because of leadership or just because of money if it's the same. But if you can make your contract look a little bit sexier to that new agent, it's easier for them to move over because they're doing it in the thought process they're going to be making more money. And they're using the comparison, the WFG's, what they're saying is confidential information, to be able to make this comparison and convince people to move over. And this is coming from people who have testified to that. Just as the foregoing courts have held such categories of information confidential, so too should this court find WFG is likely to succeed on the merits of its breach of contract. The non-solicitation provision do not equal non-compete agreements. So there's a big difference between a non-solicitation, basically don't steal our stuff, is different from a non-compete, meaning you can't go out and do insurance at all. So at non-solicitation, you can go out and do insurance, you can start your own company, you can do whatever you want, you just can't solicit the people or the clients who are at the previous company, and that's what they broke. But Eric was trying to say, well, the non-solicitation is the same as a non-compete. We can't go make money, we can't make a living, we can't do our profession because we can't go out and compete against WFG, and that's not accurate at all. You're just not allowed to steal from WFG. Or you're not supposed to, I guess. Defendant's blanket assertion on non-solicitation here per se illegal non-competes is wrong. So they're saying that what they're doing is okay because it's a non-compete and non-competes are illegal. For starters, the opposition erroneously focuses on the recitation of employee mobility policy considerations, which they're citing here. This is a red herring. So they're throwing up false objections. If you've ever been in an argument with somebody, I don't know if you ever had this happen to you, but they kind of throw out, they don't talk about the real point of what's going on. They throw up objections and things, and then you end up in this like circular reasoning where you're attacking all these different areas that have nothing to do with what's actually going on. They just kind of, I call it a smoke screens, kind of like, here's this issue, and then you go and you talk through that issue, and it was never really an issue. They just kind of were distracting you to go do that. That kind of feels like what they're doing here. And this is what they're saying that they're doing. So defendants are not employees of WFG. They are entrepreneurs of their own, independently run businesses. While defendants paint themselves as ordinary workers, their opposition separately filed lawsuits against WFG, and declarations in support thereof emphasize their business acumen, commercial and personal net worth, and highly successful independent contractors. So remember, they've got to play this game to the judge of like, I'm the poor victim and this is the big bad guy, right? And so they're just noticing that in like, this isn't just a person that works for WFG, they make a couple $100,000 a year. This is somebody like, they're lifting that back up so that it looks like they're equals talking versus one person kind of attacking the other. These representations place their obligations under the non-solicitation provisions solely within this particular lawsuit. More specifically, under the rule of reason analysis, California 5th. Importantly, this requirement that this court upheld this particular hearing. There is buttressed by this other one. So basically, again, they're going through case law and they're kind of comparing them to figure out how the judge should see this particular thing. The Ninth Circuit applied for the rule of reasoning between two businesses like parties here when analyzing a non-solicitation agreement. So again, they're trying to lift Olson up to be business versus business versus business versus employee, right? So that they're on a more level playing field when they make these decisions. Non-solicitation agreement is ancillary. WFG's agreement non-solicitation provision is factually reasonable. It only restricts former insurance agents from soliciting other WFG insurance agents within a 50-mile radius. I wonder if this is going to be edited, because that kind of became obsolete during COVID. You can build a tremendous business even outside of a 50-mile radius. You no longer really even have to have an office. So for 2 years following the termination of their agreement, again, this was kind of interesting too. Like, Eric could have bypassed all of this just by staying out of that 50-mile radius, at least in the people that he's contacting directly, and let them come over on their own. But he didn't do that. So restriction of insurance agents from soliciting while under contract. This is the other part that they're making, that Olson actually did this. So he was still under contract with WFG, which is even worse than if you had left and you were targeting people, but you're actually still working at WFG while you're targeting people, because then you have access to that confidential information. Moreover, the non-solicitation provision does not restrict defendants from soliciting any insurance agents. So again, you can still do your job. You can still solicit other insurance agents who are not registered with WFG, or from recruiting individuals to become licensed individuals for the first instance. So you can still recruit people. You can still recruit other insurance agents. You can still recruit new people to become licensed. You're just not supposed to go after WFG's people. Defendants are free to establish a competitor agency and to recruit insurance agents to join them. They just cannot target WFG insurance agent as their primary recruiting source under reasonable temporary geographical limitations, as they are doing now. Yeah, in that, I don't know how accurate it is, because it's just a post that somebody did on their Instagram. Over 4,000 agents have moved over in the last 30 days. So either they're tremendous recruiters and they were able to recruit 40,000 people in less than a month, or the other logical theory, possibly, is that maybe if some of those were WFG people. So even if the rule of reason does not apply under this particular case, which it does, California has long held that post-termination non-solicitation agreements are lawful under the section that Eric cited that were not lawful, and there's some more case study to go along with this. This restriction, actually, let's get into this one first. So Olson claims that he turned down WFG's $20 million per year offer to remain with WFG, demonstrates the bargaining power that he possesses. So this is going back up to trying to get the judge to see Olson and WFG as equals as far as business goes. So he's not just some guy that's making a couple $100,000 a year. He was offered $20 million a year as a business professional. He is certainly not David in this David versus Goliath scenario that he attempts to spin. The parties enter into their contracts as sophisticated individuals, as shown here in this particular lawsuit. Provisions hidden within the non-disclosure, so they're citing other ones. More case law. Okay, then let's get into this particular one. So the restriction only slightly affects the former employer's employees. They are not hampered from seeking employment with a new employer, nor from contracting the former employee. All they lose is the option of being contacted by him first. So the non-compete is saying that he's not supposed to reach out to these agents. Doesn't mean that they couldn't come over. But the way that is going about it, if he's reaching out to these people and trying to recruit them over, if he's running Zoom meetings and saying, hey, this is why you should move over, that's what breaks the non-solicitation clause. The restriction presumably was sought by plaintiffs in order to maintain a stable workforce with their employees. The apparent impact of limiting the new employer's business practices in a small way in order to promote the former employer's business. This non-interference agreement has no overall negative impact on trade or business. We hold this contract to as constituted is not void in its face. So this was from a different case study that they're talking about. Okay. The ruling in this particular case has nothing to do with enforcing non-solicitation agreements. I don't know if that's referring to something maybe Olson had said, whether narrow restraint exception is viable under this particular employment context. It did not conclude that worker non-solicitation provisions are prohibited, nor did it rule. All right, so they're kind of just still facing that one. The fact specifically and highly distinguishable from this case, the defendant workers are nurse recruiters, and so it's a little bit different in their profession. They're explaining why. By contrast, defendants in the business of selling insurance products, and all of their compensation is derived from the sale of those products. Defendant attempts to spin chosen profession as a recruitment in order to fall into the unique, distinguishable facts of this particular case. But unlike the nursing recruiters at AMN, recruiting is not the defendant's profession. The defendant's profession is insurance. So by defendant's own admission, they sell insurance policies, train and mentor agents, do public speaking engagements, event planning, and perform financial management. The limited non-solicitation provision in WFG agreement does not restrict any of these activities. A narrow limited restriction on WFG insurance agents' ability to solicit other WFG insurance agents does not prevent them from engaging in their profession, selling insurance products. And then they cite more case law and being able to do that. So again, I know we've said it a million times, but you can go start another company. You're just not supposed to solicit clients and recruits from WFG. Okay, WFG is likely to succeed in tortious interference, civil conspiracy, and unfair competition law claims. WFG is likely to succeed here on this tortious interference claim because defendant's breach of contract, as described above, constitutes an independently willful act, but these blatant breaches of defendant's agreements with WFG are not only independently wrongful acts. In addition, defendants have spread false, disparaging rumors about WFG with the intention of causing and the actual result of causing detrimental reliance on those statements. So again, they're using false claims about the company, and I guess that's going to be part of the argument on an agent side is, are they false claims or are they not? But they're using these claims to bring people over, and this is their livelihood. Like, it's not just moving to another company, but if you were making, $500,000, $250,000, $1 million a year, and you move over and you lose all of that, and then you end up in lawsuits, that's not something to be taken lightly. All right, so then they're claiming these people are basically helping give them information. Specifically, defendants have wrongly described WFG's policies with regards to transfer of codes between spouses, in particular from deceased and surviving spouses, as emotionally manipulative scare tactics to cause agents to leave WFG. If you remember, I think it was Cofield, they said in the last one, made a video about a lady who her husband passed away, was in WFG, and they said that WFG just basically stole it from her. She had to come out on YouTube, I'll have to see if I can find that video, and said that, the way WFG handled it was great, they took care of her, everything else. So they're using these scare tactics to manipulate people into thinking that their contract is not going to be upheld, which is a good question to ask. Like, if you don't feel confident in your leadership in WFG, obviously you're going to make a move to a leadership that maybe you do trust, so that those false, emotionally manipulative scare tactics will get people to move over. And if you're good at leading people, you're good at hitting those triggers. So defendants have also fraudulently misrepresented GFI's own business structure, again with the intent and actual result of inducing Reliance WFG insurance agents, for example, by promising particular and mutually exclusive board member hierarchy structure with GFI to various WFG insurance agents, right? They said there were 5 spots, but they had offered it to a bunch of different people. So how do all of those people get on a board if there's only 5 positions in the board? Regardless of whether these actions constitute breach of defendants' contracts with WFG, as they do, these acts are independently wrongful of for the detrimental reliance they induce on misled WFG agents. So there's going to be a lot of WFG agents who potentially, at least according to WFG, will move over and then find out some of this stuff after the fact, which is going to be interesting. I don't know. Would they let them come back and get their code and everything? Oh man, I don't know. I would hate to be in that position. So on top of WFG's strong showing that defendants have breached multiple provisions in their agreement, its tortious interference claim is likely to succeed even outside of those breaches. So WFG feels very confident that they're going to win this particular one. So it claims the civil conspiracy and violation of California's unfair competition law are both likely to succeed. Its civil conspiracy claim is based upon tortious interference by defendants with WFG's contracts and with its insurance agents as discussed above. The UCL claim is based not on only defendants' brazen tortious interference, but breaches of contract, but also on defendants' unfair business practices that rely upon disparaging, dishonesty and deception. So they're claiming, and obviously this is WFG's side of it, so this is what we got to figure out, is are they lying about these particular things, or is what they're saying true? WFG faces irreparable harm without immediate injunctive relief. This is not cited evidence of the facts. Sorry, let's kind of come back to this really quick. So Olson, this is referring to something that they stated up above, inaccurately argues in opposition to WFG not cited to evidence of these facts, but ignores the numerous sworn declarations and documented evidence submitted in support of WFG's motion. So Olson is also inaccurately argues that WFG did not show disruption or contractual agreements. So WFG was shown numerous WFG insurance agents have departed from GFI, even naming those insurance agents specifically, but WFG also requires further discovery in order to uncover the true breach of Olson's scheme, which is why it was also submitted a motion for the expedited discovery. So again, we're going back to that expedited discovery. They don't know who's involved yet. Unless they can do discovery on who Olson's been talking to, they really don't know. Along with its motion for a temporary restraining order. Can we get him to stop recruiting people from WFG? Okay, so back to faces irreparable harm without immediately injunctive relief. So if they're saying if the judge doesn't take action immediately, well, then we're going to have some serious issues. And that irreparable harm stemming from the defendant's conduct is not likely. Here it has already occurred, constantly ongoing. So over 4,000 agents as of like last week. WFG have lost numerous insurance agents to GFI based on the defendant's illegal conduct. And these are the people who are testifying against him. Those who insurance agents come their customers. Those who insurance agents come their customers and downlines, compounding the gravity of WFG's loss. Oh, so with those, so not only are the insurance agents going, and this was my question in the last one, is are they taking their customers? Are they churning these customers that they have? Again, hey, you had a policy with XYZ company, you should come over to ABC company, it's going to be better for you. They take all of those losses in the early cancellation of those policies, and then they move them over because they've had already, in the first month, they said, at least on their social media stuff, that they had over 10,000 or 1,100, sorry, I apologize, 1,100 new clients. Did they find all of those in this process of that month, or were they converting these customers to come over there? And then obviously they're taking their downlines as well. So WFG is saying it's not just the loss of a particular insurance agent, but they're taking their customer and their downlines with them, which compounds this effect because it keeps going, right? If you go, you're going to take your downline with you. And if you go, they're going to take their downline with them. So it's compounding that effect. If they're going after the first person, it's just going to keep continuing to go down until as many people head over as well. And so that brings up what I want to talk about at the end too. The quantitative harm of WFG incurs with each passing day, increases as defendants spread defamatory lies about WFG that damages its insurance agent's perception of the company and disrupts company culture by engaging insurance agent to renege their contracts with WFG. And I've had conversations with quite a few SMDs that this has been very concerning for them. It starts to make people question if they trust WFG, if WFG has their best interest, because if these allegations are true, and this is the hard part. It's a propaganda machine, right? So it's hard to figure out what's true or not. That's why we started reading these things, so we can figure out what's actually going on. But if what Eric and his team are saying is true, then it would almost make sense to move to the new company. So we've got to figure out, are those things true? It doesn't seem to be. We've caught them in a bunch of lies already. But if they were being honest, I could see why somebody would go over to GFI, because if you can't trust the company that you work for, then you should probably move over. This harm cannot be redressed by legal or equitable remedy following trial. So they're saying that if this continues to happen, they're not even going to be able to fix it after trial. So even after all this is done, let's say WFG wins, how are they going to fix those 4, 5, 6, 7, 8,000 agents that have already moved over? How do you fix that? So the faster they get through this, the better it's going to be. Moreover, defendants misuse WFG confidential information constitutes another irreparable harm. More case law. Employees stolen. This is urgent, needs to enjoin defendants as their unfolding scheme is escalating in the immediate future. On February 7th, Olson will be hosting a much publicized Break the Silence tell-all where he has promised to repeatedly and reveal secrets, industry secrets, share why he left $1 million per month income. The industry secrets that Olson intends to share publicly may very well include WFG's confidential information, which defendant apparently understands should be kept secret. Advertisements for his breaking news event have been shared more than 100 times on social media and clearly reference WFG. One posted Olson and his 24,000 Instagram followers and publicly visible to anyone on the internet, was set to a lot of people, and to song Us Versus Them. If it's us versus them, who do you think's going to win? And so maybe this TRO is what stopped him from actually hopping on there and doing that call. Olson's plan to attend the trip of Farewell WFG, as we have ample opportunity to recruit agents there. Even if Olson does not attend, he is scheming to send representatives of GFI. So they're showing that they have no regard for that non-solicitation. They're just going to recruit everybody over that they possibly can. The balance of equities weigh in favor of granting injunctive relief. We need you to, they're basically telling the judge, we need you to step in now. Defendants misrepresent their own legal position, seeking to improperly apply California statutes intended to protect employees to themselves as independent contracts, and also mischaracterize their power. Defendants are not vulnerable workers who require legal shielding and support. Rather, according to their own representations, Olson is the CEO, executive chairman, business owner, and entrepreneur, is the #1 giant in the financial industry. So they're using his own words against him here. Across North America, earning more than $8 million in net personal income from his $100 million financial services industry. These are things that over the last 12 months, Olson recruits downlines are located across the country. The limited injunction WFG seeks is only to requires defendants to comply with contracts that they, as sophisticated business owners, elected to sign and from which they have benefited. The Olsons exaggerate the extent of the relief sought, hyperbole crying that the temporary restraining order would shut down Ms. Olson's fledgling business, but defendants are welcome to both sell insurance products and recruit others to do so. On the other hand, without injunctive relief, WFG faces irreparable harm on such a major scale. So they are, again, seeking after that temporary restraining order in the public interest. They're not employees. They've misused confidential information. They're kind of repeating some of their self to stand up to this one again. And that was signed by the attorney and for WFG. So, and that was sent on February 4th. So that was probably why he didn't show up on the 7th. Okay, so hopefully that gives you a good understanding of some of the things that were kind of going on as far as that goes. So that's both the temporary restraining order and also their response to the WFG lawsuit. Now I want to go into Greg Kapp. I don't know about you guys, but I've loved some of Greg Kapp's speeches. He seems like an upstanding guy to me. Some people have said some things about him recently. They were telling me some things that he said that were disparaging recently. I don't know. He seemed like an upstanding guy to me. What happened behind the scenes, I don't know. But I wanted to play this for you guys so you could kind of see what the video, and I would love to get your guys' impression on it if you haven't seen this already.
Hello everybody, my name's Greg Kapp. I'm 72 years old. It's one of the happiest days of my life. 1 hour ago, I just resigned from WFG. WFG was the fourth company I was in. I started off meeting Art Williams, the legendary Art Williams, before I even filled out an AMA. And I joined up with them, and I learned a lot from Art Williams. But then that company went into Primerica. I was loyal to my leaders. I went in there, my heart felt good about it. I went in there to Primerica. I was with them, and then I went into WMA, to Hubert Humphrey. Why? Because my heart told it was okay, and all these moves were good for me, they were good for my family, and they were good for my team and my future team. And then after that, here came WFG. I went in WFG, became the MVP of that company, had many other MVPs after that, but I resigned today. I resigned today, and I don't know what, but I've never been this happy before in my life. I shouldn't be this happy today, because I just lost all my residual money. And you know what? I have a peace in my heart like I never had before. Why? Because I've joined up with my best friend, Eric Olson, and GFI. I've known Eric Olson for 21 years. He's been so loyal to me and my wife. He's been so loyal to my family. Whenever there were things going on in the company, he'd always be there for me. For example, when they told me as a SEVC, I was guaranteed that I get my 100% overrides, and then they told me they demoted me to be an EMD, and it was tricky because they said, we're not going to change your title on the leader bulletin, because they didn't want all my team to know about it. I didn't have to add if I didn't want to. But then all of a sudden I knew by the end of March, if I don't come up with so many points, they're going to take half my income away and give it to my upline. And what's amazing, the new president of WFG, who I never talked to for 13 months, called me on a Saturday night. And he said, Greg, I saw your situation. I want you to know I'm going to give you that exemption back again. And I said, sir, thank you. That was Saturday night. Sunday morning, I get a call from another mentor of mine who I haven't talked to in 20 years. And he started telling me, you've got to stop Eric from starting GFI. And I thought that's pretty unusual for him to call me when he hasn't talked to me in 20 years. But I'm not done with my story. It was Saturday, Sunday, and on Monday, one of the top people at the home office, whom I hardly ever talked to, said, Greg, we love you. I love you. And if you ever need any help from the home office, all you got to do is call me. Now, if you're listening to my story, doesn't something sound a little fishy? And so, you know what? That's why today I'm a free man, and I'm at such peace. Why? Because Eric Olson and his wife Sandra have so much integrity. I don't want to be with somebody that doesn't have integrity. They have such a work ethic. They're so loyal. That's why they built such a huge team in our previous company, because their teammates are loyal to them. They've been so loyal to us. You know, if you find 5 people in your life that are loyal to you, you're a blessed person, because the greatest sign of love is loyalty. And that's why my wife and I and my family feel so blessed today to make this announcement to you. God bless each and every one of you, and may God empower each and every one of you to have your dreams come true like my wife and I have had.
All right, so obviously, I mean, I don't know a whole lot of what was going on behind the scenes. If you guys have any information about that, that's obviously kind of alarming. I do think I remember a few years ago they had put a provision in place that they were trying to get leadership back into actually building again instead of just sitting on their contracts. And I don't know if that's what he's talking about. It was something about like you had to produce a certain amount of money in your base shop in order to keep 100% of your income. I don't know if that's changed. I don't know entirely what's going on with that. That's a good question to ask. But I'm assuming that's part of it. But then I think the other part is, doesn't Greg override a lot of Eric's team? So if Eric was to pull out all of those people, that also impacts Greg. So I think there's some kind of overlap there as well, that he would lose a bunch of that income by moving over if if he didn't take Greg with him. So anyway, interesting. So my question to you guys, and what I think is kind of fascinating is, I don't know if, maybe this is out there, but I don't know if Eric cares about the lawsuit. The way it looks to me, and obviously I'm not a lawyer, I don't know anything about it, but I don't think he really cares about it. And my thought process behind this is, not too long ago, Patrick Bet-David just sold PHP, right? And he had probably 7,000 to 10,000 licensed agents, maybe. I don't know the exact size of it. But the rumor is he made about $400 million doing that. So I wonder if that gave Eric a little bit of an idea of going, well, okay, I'm making 10, 12, $20 million a year. What if I could build up a company and sell it, and I can probably bring over 10,000 licensed agents, 15,000 licensed agents, turn around and resell it? That gets me to $1 billion a lot faster than it does building a company and staying with WFG for a long time, or even building a company and staying with that company. So I'm just going to put a theory out there. We'll see if this proves wrong or not in the next, I don't know, 5 or 10 years. If Eric actually ends up just selling GFI and then making the $1 billion and going off and doing whatever it is that he wants to do. So I don't know, just an interesting thought. And the reason why I say that is he's not really going, in the lawsuit, he's not really defending himself. He's just playing a shell game. He's trying to move it to other courts and go in different places and avoid being detected and avoid receiving the information that he's supposed to be getting from the court. Well, all that does is buy him time to keep moving agents over. So the more time that he has to do that, it seems like the more that he's going to obviously be able to move. So that'll be interesting kind of at the end as well. And then also there's somebody that's funding this particular business. Now, who that is, I don't know. Could Integrity come in and say, hey, Eric, we'll back you for $100 million or $200 million to go in and do whatever you need to do here? Or so, some people have said Patrick Bet-David. I don't know if I see that, but I guess that's a possibility as well. Is somebody kind of funding that from behind? I don't know. It just seems really strange to me that Eric would make a lot of these claims, not be able to back them up, not try to fight in court, just kind of move things around to prolong how long he can keep doing stuff. So I don't know. Anyway, your guys' thoughts on that, I would love to hear that as well. Hope that was helpful for you. Again, Friday we'll go through the contract together. I haven't had a chance to go through it, all of it in GFIs, so that way we can read that together and see what the heck is going on there. But it seems like even more strict than WFG's. So I don't know what Eric, again, like, do you see what I'm saying? There's so much double talk, and he's saying one thing in the lawsuit, and then he's doing something else in his own particular business. It's more strict than WFG's, but yet he's saying that it's against the law to do it in the first place. So it doesn't seem like he even cares about the lawsuit. I think it's just to draw out time so he can keep doing what he wants to do. But anyway, we'll see how it goes.